My name is Georgia Haddad, and I'm a senior manager of our public policy and stakeholder engagement team at the Partnership for Public Service. I'm very glad to be doing this webinar tonight with our friends from AFGE, Rise Up Legal Network, and Civil Service Strong. And for many of you, I know that you've come to these town halls in the past. We're very glad to have you back. But for those of you who are not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy through policy advocacy, leadership development, workforce programming, and also convening leaders across organizations and sectors. And you'll hear more from all of our partners about the work that they do as well as this town hall goes on. I want to share a few notes for everyone just as we start to dig in here. Throughout the webinar, you'll see there's a Q&A function, I think for most people at the bottom of their screen, and we'll do our best to answer questions as they come through. But of course, given the complexity and nuances of many of these topics, we might not be able to address every question or specific circumstance that comes up today, but we're going to continue to hold these town halls and other webinars on specific topics. So please feel free to put in any questions you have, or at the end, we'll have a poll as well, and you can suggest future topics if there's something else that you're looking to learn more about. And then, of course, maybe if you missed something or would like to replay anything that you hear tonight, our FedSupport hub will drop in the chat. If you're not familiar with it, we record all of our sessions and put them up on our hub and connect them to our YouTube channel, so you can find these recordings in both of those places. We'll get started tonight on the many new rules and proposed rules that are currently impacting feds, including appeal rights, reasonable accommodation and telework, updated RIF regulations, and of course, Schedule PC. So to get us started, I'd like to just quickly introduce our panelists that you'll be hearing from tonight, and they'll tell you more about their work again as we go along. So with us, we've got Michael, who's Managing Counsel for Civil Service Strong, Rushab, General Counsel with AFGE, Suzanne, General Counsel with Rise Up, Federal Workers Legal Defense Network, and Jeff, who is the Acting Executive Director with Rise Up as well. So to get us started, because I know we want to talk about a lot of things, I'm going to look to Suzanne first. Suzanne, can you give us an overview of the current state of reasonable accommodation and telework? What are you hearing? What are you seeing?
Yes, and to do that, I would like to pull up my PowerPoint. So please, oh, someone else is sharing. I'm going to send a request to share, see if that works. All right, it seems like it's working. Okay, great.
Yep.
Yeah? Cool. All right, so the key thing to understand coming into this conversation when we're talking about telework policy is that telework policy generally comes from two different sources. The first being, telework under a union contract. It's generally collectively bargained right. It belongs to the entire bargaining unit. It was negotiated, it's in a contract, and it really should only be changed through the bargaining process. So when we talk about return to office mandates threatening CBA telework provisions, that's a different legal fight, and that's one that Rushab is going to speak to more directly here soon. Specifically, what I'm going to concentrate on is reasonable accommodation as an individual right. It flows from the Rehabilitation Act, which applies to federal employees the same way the ADA applies to private sector workers. It is tied to a specific person with a specific disability and a specific set of functional limitations. And the agency has to engage in what's called the interactive process. It's a back and forth to figure out what works for both the agency and the worker. And that obligation does not disappear because of an executive order or return to office policy. This is something that's enshrined in statute. So what we're seeing in practice is that these two frameworks are both being impacted right now. And a worker might have, and often does have, telework rights under both. But agencies are kind of treating this return to office mandate as if it wipes both of these frameworks out, and it does not. So at Rise Up, our volunteer attorneys have identified sort of three different scenarios that are popping up across agencies. The first one to talk about is accommodation revocations. So in this situation, a worker has an approved telework accommodation, sometimes for years, sometimes for a decade plus. And their disability is documented. The accommodation is in place. But now all of a sudden, the agency says, well, the president has said return to office, so you have to come back. And if you want to reapply for your telework accommodation, you have to use your own personally accrued leave, or you have to come into the office. Um, that's not how this works. An agency can't revoke an existing approved accommodation just because a policy changed or a presidential administration changed. The employee's disability has not changed, and the medical documentation is already there. So the interactive process, it presumably had already happened. So if the agency believes that circumstances have materially changed, and a policy directive doesn't count, like the circumstances with the employee or the work have materially changed, then it has to re-engage in this interactive process. So that is sort of one of the problems that we're seeing right now. Second problem that we are seeing is somebody who was hired remotely, specifically hired for a remote position. It was advertised as remote, it was offered as remote, it was accepted as remote. And the person who's worked in this job has a disability. But because the job itself was remote from day one, they never needed a formal accommodation letter because why would they? The job did not require any accommodation. They were perfectly capable of doing the job as it was presented to them as they accepted it. But now they're being told to report in person. So the answer that, a lot of people hear in that situation is get your formal request in as soon as possible. Don't wait. And document that the job was advertised and accepted as remote. Document, of course, that you have a disability that requires remote work and that you can perform all essential functions from home, which should be easy to do because presumably you have been doing the job from home previously. And then finally, the third sort of scenario bucket of these sort of cases that are popping up in the individual, reasonable accommodation sphere is a blanket denial or a return to office en masse. And it's pretty straightforward. The president has said everybody returns to the office. Unfortunately, that is not an accommodations analysis. That is not the interactive process, and it does not satisfy an agency's legal obligation under the Rehabilitation Act. So, under the Rehabilitation Act, every accommodation request has to be individually evaluated. So, a blanket policy is not not intended to override that obligation. So, that is sort of a separate, in and of itself, issue. When you fail to engage in the interactive process, that can be a violation, whether or not the accommodation is eventually granted. So that's a problem as well that we are seeing quite a bit through Rise Up. And again, at Rise Up, those are the three common scenarios. Jeff is going to tell us later in the program about how to sign up for Rise Up, but I also wanted to mention that on our webpage, when you come to sign up for a consultation with Rise Up, there is a specific link on that page for folks who are dealing with a denial of reasonable accommodation for telework. Especially if any of those three scenarios that I just laid out sounded familiar, sounded like that was your situation, please do find that link for telework reasonable accommodations on on workerslegaldefense.org under the Federal Workers tab. We'll send you that link later too. But that specific link for telework reasonable accommodations will connect you with legal professionals who are evaluating these types of cases. In addition to the reasonable accommodations telework policies being revoked, union negotiated telework policies are also under fire, and Rushab is our expert on those, so I will let him take it from here.
Thank you, Suzanne. I'm Rushab Sanghvi. I'm the general counsel for AFGE. Many of you already know AFGE is the largest union representing federal employees. We have members in several different agencies. In terms of telework that is provided through a CBA, many of our units, many of our affiliates at different agencies have contractual provisions that were negotiated that provide for policies over telework. This administration last year issued guidance to try and revoke those telework agreements. And we are challenging them in many ways. In many cases, we've recently been successful. So for instance, at the Social Security Administration, we recently received an arbitration award providing that the agency's attempts to rescind telework through the contractual process was unlawful. We received a similar decision at the Department of Housing and Urban Development. And so if you are at an agency that is represented by AFGE, I would recommend that you check with your local affiliate. You can also go to afge.org to check whether or not you are in a represented unit. Because again, there's a lot going on with respect to what the unions are doing to fight for telework, but it's at an agency by agency basis. So I would recommend you, again, go to your local affiliate. One other thing I'd note with respect to reasonable accommodations in telework, we are working with Democracy Forward and others to potentially challenge blanket decisions on telework and accommodations at various agencies. So again, if this is happening to you, I would recommend that you go to your local affiliate who will direct you to the proper resources.
Thanks, Rushab. Thanks, Suzanne. And I know that there are a few resources that are getting dropped in the chat right now, and we'll also follow up with an email with more information on all of the resources that are mentioned here. Rushab, did you want to give any additional context for any of the resources that AFGE has on this topic?
No, I'll drop again. It's with telework. It's going to be a more of a an agency by agency specific issue. So I will put AFGE's general link in the chat, and again, you can go there and find out if you're a member of, not a member, if you're covered by one of our collective bargaining agreements. It's also helpful, even if you know. So, for instance, if you're a manager or you're someone who knows you were not necessarily eligible to be in a bargaining unit, it's still helpful to contact the union, because in this sort of this environment, we're all fighting together, and there are many things that we're fighting for that will benefit those who aren't covered by a contract. So it is still just helpful to go to the union that is at your agency or at your facility to check what's going on.
Great. Thanks so much for sharing. So we'll move quickly because a lot of things are going on. Another thing that we're watching, Mike, can you tell us about recent requests for information from OPM around FEHB or federal employee health benefits data? What's going on there?
Yeah, thanks, Georgia. So I'm Mike Martinez. For those of you who do not know me, I am the managing counsel at Civil Service Strong at Democracy Forward. And you're right, the FEHB issue is something that we're tracking closely. So in December, in the Federal Register, OPM posted a request for information directed at all FEHB carriers. So there are about 60 plus carriers that are in the FEHB system. So if you have insurance, federal health insurance through this system, this relates to your data. And not just your data, but any data that might be tied to your any children or any spouses or any annuitants. So it's pretty broad. It affects potentially 8 million individuals in the country. So OPM requested from these carriers medical claims data, so to the claims level, so not just broad kind of scope information, but really specific information about claims. It was a bit unusual, and that's never happened before that we can remember. OPM does have a role in monitoring a lot of this information, but that type of specific information it's unusual for OPM to have it. It often would go to, say, the Inspector General of OPM, not to OPM itself. So it's something that caught our attention, and we submitted a comment to that request for information saying that OPM really has to spell out why it needs that information. And there are many things it has to do in order to get that information, and it didn't specify that in the request. So we just wanted to flag that for you all, that this is something that happened. It did fly under the radar, but we want to let you all know that we're pushing back on it, and we hope to have more information, in further rounds.
Thanks, Mike. And kind of on the role of OPM, of course, recent rules and proposed rules suggest some changes in how OPM operates. So thanks, Rushab, for coming back on. Can you talk to us about the 3 recent appeals process proposed rules? And you can feel free to jump on in whatever order: suitability, probation, of course, RIF related rules.
Sure. I can. So, and I know Mike and Democracy Forward have been working on this a lot as well. So we'll sort of ping pong back and forth on this. But there are 3 sort of sort of, more than three actually, proposed rules that are out there right now that are going to have a major impact on federal employees if they become final. And I know AFGE and Democracy Forward have commented on these rules, and we can talk a little bit more about the comment process later in the program. But let me go first and talk about the suitability rules. So there's actually two suitability rules that are out there. One that was proposed last year and one that was proposed more recently. Combined, what these rules do is they make it easier for OPM to essentially direct the termination or direct the discipline of employees at agencies. So the suitability process is essentially an end run around the normal disciplinary process. It was originally, made to be solely about appointments, about things, whether or not you're suitable for the position based on, what you represented prior to your appointment, prior to becoming a federal employee. But what this one rule that was proposed last year would do would essentially give OPM broader authority to jump into agencies and redetermine suitability of employees for things they did after they were federal employees. And then there's a new proposed rule that's coming out that was proposed that we recently made comments on, which would now also take away your ability to appeal to the MSPB a suitability action. So, essentially they're consolidating power at OPM. OPM can now make these post appointment suitability determinations more frequently, and the appeals of those would go back to OPM. And so that's kind of, it's a pretty potent tool that OPM is proposing to give itself. And we believe that in combination with the other rules that are being proposed, the probationary period rule and the RIF rules that are being imposed, it's essentially just one way this administration is trying to sort of shift more and more power to OPM to remove federal employees and undercut the agencies who, if as it's agencies, it's your supervisor, it's your manager who really knows what's needed at the agency. And whether or not your position or some misconduct you're alleged to have done actually affects the agency. So that's kind of the broad overview of the suitability rule and sort of all the rules in general. And we'll go into detail on each one. I didn't know, Mike, whether you wanted to take the RIF or probationary one next.
Yeah, happy to. And maybe just a couple sentences on the context of what OPM is doing broadly. So I think many of us have heard of the spoils era of the 1800s and the Pendleton Act and what happened after that to create the modern civil service. But out of that process was the Civil Service Commission, which functioned for about 100 years. And that really included policymaking and adjudication and union rights all in one agency. So in 1978, when the CSRA came around, there was a decision by Congress that didn't work, that policymaking should go to OPM, that adjudication should go to the MSPB, that labor issues should go to the FLRA, and then later on we had the Office of Special Counsel. But what's happening now is that OPM is trying to kind of piece back parts of what looks like the Civil Service Commission that did not work. So OPM is taking back to itself, as Rushab said, the appeal right that would normally go to the MSPB for suitability, for probationary appeals, and for RIF appeals, which we'll go through kind of one by one. So maybe I'll kind of just go to the RIF appeals one because that's a big one. We've all heard, or we may have experienced RIFs in our agencies. I think about 17,000 employees were RIFed last calendar year after the inauguration. So it's a big number. Many of those RIFs were done improperly. Many of them were challenged in federal court or at the MSPB, most likely at the MSPB. And what that did was just, it really bogged down the processes at the MSPB. But there are processes that are in place, and they have been for the past 40 plus years. And that includes the right to discovery, the right to a hearing, and the right to eventual review by a court, by the federal circuit. So the RIF appeals and proposed rule would take that from the MSPB and put it into OPM. And with that, you would remove the right to discovery, the right to a hearing, and the right to federal circuit review. So it's a big change in the way RIF appeals are handled. And it also does one big thing that it is kind of a bit more under the radar, the burden of proof. So at the MSPB, the agency has an initial burden of proof to show that their reason for a RIF was valid. So they have to, say why they're doing a reorganization that's valid, why they ran out of funds in a way that makes sense. So they can't just use it as willy-nilly to cull the civil service. What this new proposed rule does, it puts the burden of proof on the employee. So it says you, employee, must show that this RIF was done improperly. So it's really hard to do for the employee to do that without any discovery, without any hearings. And so it is a big obstacle. So we think it's pretty important to track. We're tracking it closely, but we're not sure if there will be litigation on it, but it is an important change that's being proposed.
Thanks, Mike. So I'll follow up on the RIF rule. So there's actually one other thing I wanted to note. There's actually two RIF rules that have been proposed. One on what Mike had just said, taking sort of this power again and putting it into OPM. But then there's also a RIF rule that's being proposed that was more recently proposed that's going to change how RIFs are conducted in terms of like ranking and essentially take away some of the seniority preferences that are currently in the RIF rules. That's another thing, again, that's going to change this process and give agencies more power. And we'll talk later about the performance appraisal rules that are also coming out in a second. But there's one other rule, that was proposed, and again, it's another one of these compendiums where there's two rules that combine. And this is involving probationary employees. As many of you already know, probationary employees don't always have the same rights as employees who have passed their probationary period. But they traditionally they still had the right in certain instances to appeal to the MSPB. And there was also rules on why an agency could terminate a probationary employee. It couldn't be just essentially with no cause or no reason. So in June, OPM actually issued a new probationary rule that unilaterally rescinded a part of the regulations and imposed what's called a automatic what they sort of are using as an automatic separation mechanism. So essentially, in the past, probationary employees would become full employees after their probationary period had passed, unless an agency took action to terminate them. Now, essentially, there's a flip. There's a flip in that. Under the new rule, probationary employees no longer are automatically separated, purportedly, if the agency doesn't sign something saying we want to keep them on. So it's kind of the default is you no longer are an employee after your probationary period ends, and who makes that determination is designated to someone at the agency. And so there's ways for that to be abused. And again, going back to the history Mike spoke of, right, to sort of eroding the nonpartisan and sort of the sort of neutral nature of the civil service. So that came in June, and that came unilaterally without notice and comment. But then more recently, the OPM has proposed a rule taking away probationary employees' ability to appeal any type of action to the MSPB, and instead vesting most of that power in OPM. And so this just sort of ties into all of the other rules where OPM is giving itself more power. This second rule, they did actually go through notice and comment, and AFGE and others have commented. And so it isn't final yet. The comment period has ended, and no final rule has been published. But that's out there as well. And this also ties into again, this sort of outside of this OPM appeal scheme, there is also a rule being proposed, or rules being proposed on performance that I think Mike can talk about.
Yeah, thanks. So each one of these, there's kind of three that are working together here. The one's relating to the SES, the Senior Executive Service, one relating to kind of general schedule employees, which is most of the civil service, and those related to what they call SLST employees, which are really scientific, technical, kind of senior leaders that are kind of sub SES level, but are more specialized. So each of these basically has the same centerpiece, that ratings over time. So, once a year you get rated, often on a scale from 1 to 5, but it can vary from agency to agency, but often from 1 to 5. And that the ratings over time have really clustered in the 4s and 5s. We've all might have experienced this. That's something that we hear often, that the ratings often do cluster. OPM sees this as a problem. It says that the ratings should be more distributed from 1 to 5. But for the past 40 plus years, there's been a ban on forced distribution. What does a ban on forced distribution mean? It means you can't really grade on a curve. So, when you're in school and some folks could get a B and some get an A, some get a C, but you kind of really had to smooth out the bell curve in that way. That has not been a part of the federal performance ratings, because by statute, you have to be compared in a qualitative way, objective way, based on your job duties, not based on your coworker. So what OPM is doing is saying you should be compared to your colleagues. You should be, and then put on a forced distribution of ratings. So it's possible that you'll have a team of 20 employees, and some will get 5s, and some will get 4s, and some will get 3s, and some will get 1s, because they're actually getting rid of the number 2. They said no one uses 2 anyway. Let's get rid of it. So it's going to be a cluster from 3, 4, 5, and 1. And 1, it really puts you on the path to termination. So that is what OPM is doing. It's proposing for all these tranches of the civil service. It also removes the right to grieve certain low scores, low ratings. It does a variety of other things. And what OPM is I think just trying to do more broadly is to use that in conjunction with things like the RIF rule to say that performance is really what we care about, but in this way that has never been done before under the modern civil service, and that potentially combined with the RIF changes that are proposed, it would make performance ratings paramount. It would be the number 1 factor in whether or not you're retained in a RIF. So those are all kind of working together. And we at Civil Service Strong are putting together explainers on these proposals. We hope to circulate them soon. Maybe we can circulate them after this meeting, and it'll kind of guide individuals through what are the main topics that could be commented on. The comment period for these 2 rules related to SLST and for the general schedule appraisals ends next week on the 26th. So if you are an organization or individual who wants to comment, we encourage you to do that. The more individual comments, the better for things like this. And the last I looked, there weren't that many comments for either of these rulemakings, and we really need to get your voice out there if you have a good comment to contribute. We'll hopefully circulate those explainers soon, so you'll have a kind of a guide about where to look.
So if I can, I want to just a couple final words on the rules, because I know we're talking a lot and we're talking about rules, and it's kind of scary, and we're basically saying all these bad things that OPM is proposing. And so I think Mike mentioned commenting is really helpful. I know DF, Democracy Forward, has done comments themselves, and AFGE has done comments as well. So it's also important that you support these organizations. If you can be a member of a union. And pretty much anyone can be a member of a union. Just make sure you sign up for that union. Hopefully if it's an agency that AFG covers, you can sign up to be a AFG member at afge.org, or there may be another union that covers your agency that you can sign up for. But then one other thing I wanted to put out there is, all of these rules we were talking about, except for the one of the probationary employee rules, none of them are final yet, right? And so while these scary things may be proposed, that doesn't mean that they're going to happen. And there are many different things that could change before they become final. Our comments, the comments that you make, the comments that our organizations make might change the contours of the rules. And then there's possibly litigation later as well, depending on what happens, whether, if an agency doesn't respond to those comments, or if they act in a way that we think we can challenge under the Administrative Procedures Act. So I just wanted to put that out there, because we're saying a lot of scary things, but we're trying to say this more so that we can activate you, get you involved, warn you, and make sure that we're all working together to make sure that the harms don't actually end up happening. So I just wanted to put that out there.
Thanks, Rushab. Thanks, Mike. And I'll just remind the audience that if you have a question, please feel free to drop that in the Q&A function. Mike, you mentioned the interaction with RIF a little bit in your previous comments, but anything else you could share on the proposed RIF rules? What does the proposed rule suggest, and who does it apply to, and who does it not apply to?
Yeah, so I think Rushab mentioned that this other RIF rule. So aside from appeals, you have kind of a broader restructuring of RIFs generally. And the RIF regulations are complicated, they're complex, and they've been around for a long time. So the number one thing that OPM is trying to do is rework the factors of retention. So generally, when there's a RIF process, individual employees are evaluated in comparison to their coworkers. And there are certain factors that the agency will look at to say who should have retention priority over others. So it's been the case since the beginning of these regulations that tenure and length of service have been at the top, and performance has been somewhere towards the bottom. Veterans' preference has been right kind of in the middle. So what OPM is doing is saying it actually should be flipped, and that performance should be at the top based on our new force distribution model, and that tenure is really kind of a tie-breaking feature at the very bottom of the priority list. So that's kind of the big change. Another thing is that until now, until this proposal, probationary employees could also appeal improper RIFs. So if you were a probationary employee and you felt the processes were done incorrectly, you could file an appeal to the MSPB as a probationary employee. And what this proposal does is removes probationary employees altogether from the RIF processes. So if you are on probation, you're not even included in the analysis. You're separate. So by the plain logic of it, you wouldn't have a right to appeal because you wouldn't even be included. So the way OPM justifies that is it says that because they don't have the right tenure status, they wouldn't be included. And it would allow the agency apparently to decide separately whether it wants to keep or remove probationary employees separate from the RIF analysis. So that is a big change. And there are a few other changes that we'll also put out an explainer for in the next few days. So we hope to have that up on our website soon.
Great. Thanks, Mike. I might move backwards for just a moment because we had a question on reasonable accommodation. Suzanne or anyone else on the line, is there a time frame that agencies or employers are required to make a reasonable accommodation decision?
There are no hard federal deadlines for RA decisions. The EEOC says the process must move as quickly as possible, and that an unreasonable delay is in itself a violation. But of course, there's no specific number of days written into the law. OPM does have a suggested timeline of 20 to 30 days, but it's not a legally enforceable standard, but that's about what it should be. And then on the interim accommodations, no explicit requirement, but if a worker already has an approved accommodation, the stronger legal position, in my opinion, would be that it should stay in place while the agency reconsiders. And pulling an existing accommodation before a re-review or a review is complete, I think is legally risky for the agency to do. But is that stopping agencies at the moment? Not necessarily. So I think the bottom line is for workers, document everything, date of request, who received it, response, non-response, because those paper trails are really important to the case.
Thanks, Suzanne. And I'll just remind everybody again that there's a lot of resources that are getting dropped in the chat. Don't worry, we will follow up. There's several different takes on comments that have been mentioned. I know that Natalie just dropped the partnerships, a blog over some of the partnerships comments on RIF suitability and probationary appeals. So feel free to look at that, and we'll send a few other ones along. Moving on, I know that an EO on Schedule PC has actually not come out of the White House yet, while we're waiting to learn more about that and how the new rule will actually be implemented. Mike, can you just give us a reminder? I know our last town hall, many of you maybe tuned in for that, was actually focused on the history of Schedule PC, but it's been a while and we're still all sort of bracing for what that might look like. So could you remind us of where we are with Schedule PC and what that comes from, what it looks like?
Yeah, happy to. So just kind of doing a couple steps back for folks who are not as steeped in Schedule PC in their everyday life like I am. I feel like it's taken over my existence. In 2020, the Trump administration introduced a new accepted service schedule called Schedule F. I think it was in the news. It became one of their centerpieces for the civil service, but it never really got underway. By the time agencies started sending positions to OPM, there was a change in administration, and the Biden administration eliminated Schedule F. In 2024, the Biden administration then put out a rule that basically tried to address the reasoning for Schedule F and to show why it was improper. The centerpiece of Schedule F was a statutory exception. So most civil servants, after they meet their probation requirements or trial period requirements, they get adverse action rights. They get protections from termination, except under certain exceptions that almost all relate to political appointees, or there's a phrase of confidential policy determining, policy making, or policy advocating positions. So that has long meant also Schedule C political appointments, and that's what the 2024 rule said. Now, fast forward to 2025, under an executive order, right after the inauguration, the president again reinstituted Schedule F under a new name, Schedule Policy Career, and with the same centerpiece, trying to make use of the exception for confidential policy determining, policy making, policy advocating positions. They seem to think that regardless of how this term has been used over time, that the plain meaning of those words are what actually matter. And so the president directed agencies broadly to start putting together lists of positions that could fit within these categories and send those to OPM. And OPM would then run an analysis based on its regulation, and then it would send those positions to the White House, and the White House would then issue an executive order formally putting those positions into Schedule PC. So OPM estimates that about 50,000 positions will be put into Schedule PC, but there's really no boundary. It really depends on how the president decides to use this, which is kind of the scary part. It could be many more than 50,000 potentially, or less. It's really OPM kind of cedes some of the discretion back to the president to make that determination. But we have been waiting for this executive order, kind of the last piece, to see which positions are actually put into Schedule Policy Career. You may have heard from your agency, some positions are already kind of understood that they will go into Schedule PC. So we started hearing from folks that very valid concerns that this will happen to them. So that is where we are. The rule is fully effective as of a few weeks ago. And now it's up to the White House to issue an executive order putting the positions formally in Schedule PC, which would then trigger lots of things. For one, litigation has already underway, but it would kind of wrap it into a new gear. But for civil servants, it would attempt to remove your adverse action protections. And that's really the gist of why that schedule exists, is to move positions in and then remove protections.
Thanks for sharing that. Anything else, Rushab, others that you've been hearing, or things that we've seen agencies do over the last few weeks in preparation for this?
So we haven't heard anything in specific, but I will say that if you hear anything, it's important to let, if you have a union, to let them know. And you can also, again, go to resources at Democracy Forward or AFGE.org.
Yeah, and I would say maybe one other thing. There was a OPM guidance on Schedule PC. There's actually two. There was an initial and a follow-up guidance. One of them includes a template for agencies to give to individuals who will be placed in Schedule PC, and it attempts to say essentially that you acknowledge that you were placed into Schedule PC and the position has no adverse action rights. So there's a kind of a question that we're all trying to grapple with of what happens when employees receive this form. So I think we're putting our heads together, and we're trying to think of the best advice to give to employees on that. But you may start seeing some of those forms circulating once the positions are formally announced.
And we'll certainly follow up with a town hall. And I know all of our organizations are working hard at trying to create resources to help folks understand their circumstances, what you can do if you are placed on schedule PC, how to better understand the environment. But we'll certainly continue to be communicating with all of you who subscribe to our newsletter, as well as all of the other organizations that are present here. So given that we've moved through a lot of information really quickly, please don't be shy. Feel free to submit questions through the Q&A function. But with some of the time remaining, I'd love to hear from the panelists about some of the resources that your organizations offer. And I'll pass over to Jeff to get us started on what Rise Up is doing right now and how folks can connect with them.
Thank you, Georgia. First, let me say, as I've said before, all of us at Rise Up hope the day will come when the services we provide are no longer needed by federal workers. But until that day does come, Rise Up will be here for federal workers, current and former. What does that mean? We provide a range of services for federal workers. One of the most significant is we offer free up to 1 hour consultations with our volunteer lawyers to educate federal workers so that they understand their legal situation and their options going forward. That is generally provided through one of our Zoom virtual legal clinics. To obtain a consultation, you simply have to go to our website, workerslegaldefense.org, and click on where it says Federal Workers at the top of the page. Then fill out the short form. We hold several legal clinics each month where we conduct free consultations. Qualify for a consultation, you will have a brief interview with one of our volunteers, either beforehand or at the clinic, to determine if you have a federal employment issue and are not currently represented by an attorney. When you respond to an invitation for a clinic and we have a place for you, you will receive a link to the Zoom meeting where you will be placed into a breakout room with one of our volunteer attorneys who will provide your free consultation. At our clinics, we also have expert federal labor law attorneys present. If your volunteer needs assistance in advising you, they can leave the breakout room, consult with one of our experts, and return to you with the answer. Even if you've already received a consultation from Rise Up, if you have a new issue, you can return to our website and sign up for another free consultation. We also offer a variety of other ways that we support federal workers. We have numerous guidance documents available on our website on subjects such as MSPB procedure, RIFs, and a variety of other topics. We also have recordings of some of our prior webinars. Simply click on resources at the top of our homepage. Suzanne, our general counsel, issues a weekly update on legal developments called the Solidarity Docket. Click on news at the top of the homepage to read it. We maintain a litigation tracker that provides information about the numerous lawsuits relating to federal workers that have been brought. You can review that by clicking on litigation tracker at the top of our homepage. We at Rise Up know that this administration's unprecedented attack on the federal workforce is doing immense harm to individual federal workers and the ability of the federal government to function. We will be here to support federal workers as long as the need continues. Thank you to all federal workers for your valuable and unappreciated service.
Thanks so much, Jeff. There's a few other questions coming in, but I did want to give a moment for others to share any additional resources that they had in mind that haven't already been dropped in the chat. And again, I know we'll send out lots afterwards. Okay, great. Suzanne, do you mind jumping on? We've got a question about the FLRA.
Sure. I see it in the chat. It says, when agencies violate collective bargaining agreements and unions file unfair labor practices, my understanding is that the FLRA adjudicates, and that is partially correct. I am also hearing that the FLRA is favoring agencies more in this climate. Can you comment on that? Yes, happy to comment on this. When agencies violate collective bargaining agreements in the federal sector, unions have the option of bringing a grievance under the negotiated grievance procedure that covers any rule, law, policy that the agency violated, including unfair labor practice charges. So a lot of those cases end up before arbitrators, not necessarily at the FLRA. The process for obtaining an unfair labor practice charge at the FLRA depends on the existence of a general counsel at the FLRA. There is not a general counsel at the FLRA. There has not been one confirmed since President Obama was in office. There is somebody who is currently up for the position. He is awaiting a Senate confirmation hearing at his GAC, but that has been delayed. My understanding is because of the confirmation of Mark Wayne Mullen that was happening today. So that's all been pushed back. So the short answer is nobody can file a ULP charge at the FLRA right now because there is no general counsel. However, those cases do reach the FLRA by going through the grievance arbitration process and then are possibly reviewed in an appeals process we call exceptions by the entire FLRA, the whole authority, which is made up of 3 different members. And it's generally 2 members from the party in power and 1 member from the minority party. So right now that means there are 2 Republicans and 1 Democrat on the FLRA. They just recently got that full quorum of those 2 Republicans and the 1 Democrat. So they have just started, I believe the new members' first decision with the FLRA just came out within the past couple of weeks. So we haven't really seen what they've done yet. But to answer your question, traditionally speaking, I think legal watchers and the people in this space do not expect this particular FLRA to cover itself in glory when it comes to workers' rights. So I think a lot of people are avoiding the FLRA because of sort of the fear of what might happen there. So hopefully that answers your question. It was my very long-winded explanation about how the FLRA works and unfair labor practices and why we haven't seen those in very many years because of the lack of general counsel at the agency.
Thanks, Suzanne. I see another question from somebody who accepted VSIP and is curious about their ability to potentially appeal. Mike, I think you can take this one for us.
Yeah, so I think kind of the answer is it depends on what you signed. So voluntary service, the incentive program is generally designed to, we call it it's called a buyout. Is that gives you a lump sum of money, but often in exchange for the release of claims. So we've seen that also in the deferred resignation and the fork in the road, where the incentive was offered, but it was for in exchange for release of claims. I would be surprised if you didn't sign something like that. I think it's important to take a look at what you did sign, and that may answer your question. But I think generally speaking, VSIPs come with a waiver of rights.
Thanks, Mike. A lot of things for folks to navigate right now. Appreciate you all sharing this information. And again, stay tuned to, I know a lot of different resources, but we're all sharing each other's information. So you'll find it in multiple places, and we'll continue to provide sessions like this one. Before we start to close out for the evening, I just wanted to flag that my colleague Natalie is going to initiate a poll quickly. We do this at the end of all of our sessions. It's just to make sure that we have a sense of how these are working for you, if they're meeting your needs and are answering questions that you're curious about. And then, of course, open the door for additional sessions or hearing from you the content that you'd like to know more about in future sessions. Before I close out, anything from any of our panelists to leave folks with this evening, or anything that we didn't get to that you've been hearing questions about or is top of mind for you?
I did want to mention the DHS shutdown because we are now in week 5 of a partial government shutdown that the Department of Homeland Security employees are either working without pay or furloughed. The effects of this are very, becoming very visible to the public. TSA staffing shortages are creating very long lines at airports across the country. But unfortunately, that visibility has not yet translated into a faster resolution for these workers. As of yesterday, my understanding is that the White House released a written proposal outlining, 5 areas where the administration says it's willing to make policy concessions. But so far, the members of Congress have said that offer doesn't go far enough. And essentially, we're at a stalemate between the president and Senate Democrats. And there's no meeting between those parties currently scheduled, is the last that I heard. So where does that leave DHS workers? in the same exact place that they have been, which is waiting without a clear timeline, and in many cases without a paycheck, or at least not a full paycheck. So if you're one of those workers or know somebody who is, FEA, F-E-E-A, the Federal Employee Education and Assistance Fund, provides emergency loans and grants to federal workers in exactly this situation. So that website is, I think, also something we can provide in the chat as well.
Thanks, Suzanne. Yeah, we will drop FIA in the chat, and I know that there are also several mutual aid efforts taking place right now, so we'll share some of that as well. But as we wrap up this evening, I just want to thank everybody again. And as I mentioned, as you navigate your current situation and look for resources, please check out the things that we shared in the chat, including the partnership's FedSupport hub, which offers a range of plain language explainers on issues like what we talked about tonight, but also career support for folks who are maybe transitioning or considering transitioning out of government, and many other things designed specifically for feds to keep you all connected and informed. And also, of course, encourage you to visit all of our partners' websites, AFGE, Civil Service Strong, and Rise Up. They're in the chat. We'll drop them one more time. But for all of you, thank you so much for being with us this evening. We know that everyone is really busy and evenings are a precious time. So thank you for taking the time and sharing it with us. Please keep questions and topics coming. You can always email us. You can put it in that pop-up poll that you saw on your screen or see on your screen still. And we will always try to incorporate the topics that you ask for in future sessions. So for all current and former feds joining us tonight, thank you for your service. And we look forward to the next time we get to see you. Thank you, everybody. Have a good night. We'll drop a few more resources in here. If you didn't catch them all, take a minute and grab them. But don't worry, we'll follow up in an email.
I was like speed typing a Q&A
Yeah.
answer.
I know it takes a second. Thank you, everyone. Have a good night.